Good morning. My name is Bruce Provan. I'm the Managing Director of Page Provan. We're a firm of lawyers in central Brisbane that practice exclusively family and fertility law. I want to talk to you this morning about international child abduction. Now, what that means is that parents removing children, either taking children from Australia or overseas or bringing children to Australia from an overseas country. There's a convention from back in 1988 called the Hague Convention. And what it is a convention between a number of countries where they have agreed that a child is abducted and removed from the country of habitual residence to another country. Then the country that they're removed to has an obligation to have the child returned to the country where they were the habitual resident. So what this means in practical terms is that if a parent were to take a child overseas without the consent of the other parent to a Hague Convention country, then what would happen is that the other parent would approach what they call the central authority, which is a government department, who would then get in contact with the central authority in the country overseas. So in that country, they would be required under the convention to take action through their courts to have the child returned to Australia. And that involves making an application to a court in that country to have the child returned. Now, that sounds simple, but it's not as simple as it sounds. And one of the reasons it's not as simple as it sounds is because there are certain exceptions where the child may not be returned. So, for example, if the child is over 16, the Hague Convention won't apply. But there are other certain defences now. They include if a child has been in the new country for over 12 months and is settled, the court in that country has a discretion not to return the child to Australia. Also, if the court considers that there is a grave risk to the child in the country of origin, the court has the discretion not to return that child. There's also the issue that some countries who are signatories to the Hague Convention don't always enforce the convention. And each year, the US State Department releases a report that comments upon which countries are abiding by the Hague Convention and which aren't. Now, these cases, when they get to court, can become quite long and convoluted. Now, in a straightforward case, the court is going to hear the case and order the return of the child to the country of habitual residence straight away, and that should all happen within a matter of weeks. But there are cases that can drag on for a long time. There was a case in Australia about a decade ago of 4 retained girls who were brought to Australia by their mother, and she refused to return them. And that case went through the courts for several months before the girls were eventually returned to their father in Italy. So the criteria that the court has to look at is, what is the country of habitual residence? In other words, what is the country that these children live in? And I gave the example of the 4 Italian girls. Those girls had lived in Italy for a number of years. In fact, they had lived there since birth because they had lived with their father post-separation. The mother was from Australia. And the convention also talks about right to custody. So to make an application, it has to be satisfying that the parent seeking the return of the child has rights of custody pursuant to legislation in that country or a court order. Now, that question of rights of custody and habitual residence is more clear-cut where there's a court order. So, for example, if an Australian parent has a court order to say that the children live with them and the other parent takes the children overseas and return them, the existence of the court order won't be decisive, but is more likely to indicate to a court in the overseas jurisdiction that the Australian court is seized of the matter and that the child should be returned. Now, if there's no court order, that doesn't mean the child can't be returned. It might just be a bit more difficult to show that the child is habitually resident and that the parents have rights of custody. As I said, there are a number of exceptions, and one of the exceptions is acquiescence. So, for example, one parent takes the children overseas with the consent of the other parent, and the other parent wait over 12 months to start proceedings for the return of the child. The court may, in that situation, find that the other parent has acquiesced in the children living overseas. So what we see is there's two sorts of abductions. One abduction is where children are taken overseas without the knowledge of the other parents. The other one is where the children go overseas with the consent of the other parent, but then the children are returned at the agreed time. If you have any concerns about international child abduction, please contact us at Page Provan. It's Bruce Provan. I'm the Managing Director of Page Provan.